spending time on your thanks for spending time on your Monday afternoon to have some legal chat. I'll give you 20 seconds about myself, just so you know who I am. I've been a non-exec director for England Gymnastics since November 2016. I was an in-house lawyer at the time and thought I want to get involved with the sports body. England Gymnastics were looking for somebody, so I've been on the board for the past 3 years. So I understand quite a lot of the issues that gymnastics, as well as other sports, are facing just now. I want this to be as interactive as possible, to make it as interesting as possible. So I think there's three kind of key areas that have come through in questions before the start of this webinar. So we'll focus on them, but if there is anything, then please interrupt me or put something in the chat and we can address it. And I'm in no rush. So if 3 o'clock comes and goes and we're here till 3:30, do not worry about that at all. So any legal issues, we will get them covered. So I am Adam Lovatt from Lovatt Legal Limited, and we're discussing today coping with contracts and insurance challenges post-COVID-19. And the first topic that came across quite a lot in the questions was furlough, and how much notice is required when taking someone on or off furlough at very short notice, as and when the need arises. And if somebody refuses to come back to work due to health concerns and wants to work from home, what can we do? So let's start with taking someone on and off furlough, because that's obviously the first point. So the furlough scheme's changed slightly as of the 1st of July. So, and Jessica was asking this just before everyone else joined, you can now put part-time work on furlough. So effectively, someone that might have been in 5 days a week, 9 till 5, you can now say, I want you to come back 3 days a week, 9 till 5. That ability now exists. So the furlough scheme has been relaxed quite a lot. And the employers have total flexibility over hours and shift patterns in terms of when you want people to come back in to gyms. In terms of, and a question just flagged up from Jessica, which I'm going to address actually, how much notice do you have to give anyone to come back in? The answer is actually none. Now, that doesn't mean that I can phone someone at 2:05 on Monday and say I need you at 3 o'clock this afternoon, but I think the key word is reasonability. So if you think that someone can come back on Wednesday, phone them up and say, Joe Blogs, listen, we're back up and running on Wednesday, furlough's coming to an end, I'd like you to come back in. The only exception to that is if there's a written agreement with the individual when they've gone on furlough, and the written agreement says there's a specific period of time which has to be notified to them before they come back in. Now technically, everyone should have been given an agreement when they went on furlough, but I appreciate it's unlikely that's happened across the board. But ideally that should have happened, and within that there would be a notice period which says how much notice should be given. But simple fact is, it's common sense. Pick up the phone, drop an email to the individual, and subject to them not wanting to come back in because they're nervous about coming back into the setting, which we will come on to, then I would imagine most people are wanting to get back to work. So an element of reasonability, but there is no specific time requirement to be given to the individuals. What I would say is when you've got an employee coming back in, make sure they feel as comfortable as possible. And from a legal perspective, I think it's important to explain to them what measures have been taken by you to make sure that they are as protected, for want of a better word, from COVID-19 as possible. So what social distancing measures do you have in place? Are there going to be staggered start times? So are you going to be in a situation where you say to some employees, come in at 9, some at 11, some at 1, and change the shift patterns? I think it's important as well just to let them know about hand washing requirements, any PPE. And when they come back in, to actually say to them, welcome back, I'm going to give you a 10-15 minute orientation or explanation on what measures have been taken. I think it's important that the employees feel, and I use the word employees, I appreciate it's quite a generic term, but I hopefully understand what I mean by that. But I hope the employees feel as welcome as possible and as comfortable as possible, because there is a lot of nervousness. People might have experienced family situations. Other people might have had friends that have suffered from the virus. So I think making them feel as comfortable as possible is important. So going through a proper explanation, orientation with them is very, very important. Now, obviously, I've covered this slightly in terms of Jessica's question about how much notice you have to give, but I do think there's an important point to consider in terms of childcare requirements or family dependents who might need time from people as well. So whilst reasonability, saying I need you on Wednesday, I think you can do, legally you can do it, I think it's worth noting that some people may need to find childcare at short notice if suddenly you're in a position where you want them to come back into work. So whilst there is no minimum requirement subject to what any contract or any notice said to them when furlough started, do bear in mind there are childcare issues and other issues that people might need to think about as well. And indeed, there might be situations where people say, I don't want to come back in at 9 o'clock because I don't want to be in public transport at peak time. Can I stagger my start time? And therefore, can I work 11 till 4 instead of 9 till 2, for instance? So flexibility is key, but as an employer, the right really does exist with you in terms of saying when you want someone to come back in. The government contributions towards furlough are changing over time, and I'm not an accountant, so I'm not in a position to give you advice on that. But what I can tell you is that they will still, to the end of July, give up to £2,500 a month, and that's 80%. It does start to taper off over August, September, and October. So in August, there's a requirement for the employer to start making pension and national insurance contributions, and that's still on an 80-20 basis, but the contributions have to come from the employer. When we move into September, it's a 70-10 split, so 70% will be given by the government, 10% by an employer. Again, national insurance and pension comes from the employer. And then October, it's a 60-20 split, so 60% from the government, 20% for the employer. And then you get NI and pension contributions from the employer as well. Of course, the employer can make up that additional 20% that exists in any of those individual months as well. Ideally, the government want the furlough scheme to end at the end of October, but wouldn't surprise me if they push it out till the end of the year. But that's my personal opinion. It's not anything the government have done yet, but I know Labour are pushing to have it extended to the end of the year. So it's quite possible the government will do so, and I wouldn't be surprised if the 60% becomes 50 and then 40, and then it's ended at the end of December. In terms of employees that don't want to come back in, now obviously the nature of gymnastics as a sport makes it a bit more complex than maybe other sports may have. Now obviously you've got two types of employees. You might have people that work in the office, and you might have actual people that are working with gymnasts and on the equipment. So there's quite a difference there to think about. In terms of working from home, if someone doesn't want to come back in, what rights do you have as an employer? Well, you can extend the furlough. So you can say to them, I want you to come back in on 1st of August. They say, I'm not comfortable coming back in the 1st of August. Their job can only be done on premises, on site. So the option there might be, well, I'll extend your furlough. So they remain as an employee, but they won't carry out any services. That's on the basis that you want to extend it on a full-time basis. Of course, you could say, well, you can do some work from home on a part-time basis, and then you've got some work from home on a full-time basis. The other option that you've got is to say, if you don't want to come back in, you have to take some annual leave. So I think there's going to be an issue with a lot of annual leave stored up towards the end of this year. So you might say to them, can you bring some of your annual leave forward until you feel comfortable to come back in? That could buy them another 2-3 weeks. Again, an open conversation with employees and saying to them, what reasons do you have for not coming back? Are you concerned about PPE? Are you concerned about the cleanliness? What are the issues? And you can have an honest conversation with them to try and resolve any issues that they may have. Ultimately, if they refuse to come back in and everything's in place for them to come back in a safe environment, you can terminate the contract. I'm not suggesting you do that, but if they are steadfastly refusing to come back in, particularly if it looks like it's going to drag into next year that they're not wanting to come back in, and you're having to meet their full salary, the option might have to be, you're not performing your services under your employment contract, therefore I've got no option but to terminate you. It's harsh, but I do think there's an element of that might be what happens. Now, I've got another question about employees and coaches, if they live with anyone that is categorised as vulnerable or high risk, what do you do in that situation? So that's a very good question. I think the answer to that question is that the need for people to stay indoors if they are vulnerable or high risk is reducing. I think the government has now said that people who are in a vulnerable capacity can now go out. If someone's reasoning for not coming back to work is because they are looking after someone in that category, then I think you just have to go through the measures that you have in place to make sure that coronavirus is not going to exist in your premises. So that might be the hand washing, it might be the PPE. You have to accommodate their needs as much as you possibly can. But ultimately, there has to come a point, and I don't think we're there yet, but there has to come a point in a month or two's time where that doesn't become an excuse that people can use for not going back to work. I appreciate that everyone's got different circumstances and situations, but I think that there has to be a need for people to get back to work. And there comes a point where you say, I understand you're living with someone who's in the vulnerable capacity, but every winter there could be a severe flu outbreak in the country and you would still go to work in that situation. The risk from coronavirus has dropped. It's not as severe as it was, therefore you should be coming back on to the premises. I think what I will do at this point, is there any questions specifically on furlough and the issues I've discussed before I move on to the next topic? Obviously, it's a kind of move.
Yes. Yeah, I have a question. Okay. Let's say that the percentage of furlough that the government is offering for our employees has dropped down to 60%.
Yes.
But at that stage, I still don't have enough work to offer my staff for the remaining 40%. Can I, at that point, send them a message or ask them whether they would be prepared to go down to part-time work?
Absolutely. Absolutely, you can. Now, if they refuse, we'll come on to that in a second. So yeah, absolutely. The ball's in your court. You can say to them, but I think the best example, Jessica, let's actually move to November. Let's move beyond furloughs. Let's move to the point where furloughs ended, whether that be November or December, wherever it may well be. So you get to November, you've got someone who is working, say, 30 hours a week for you, and you've only got enough work for 15. I think what you have to do there is be honest with them and say, you're going to be sitting here twiddling your thumbs. I can offer you part-time work for the next, say, 3 to 6 months, and we can then revisit again to see if it becomes a full-time role. But I'm unable to give you full-time work at this time. Now, whether the person takes that offer or not is a difficult one, but they may well look at it and say, well, I'd rather have a part-time job than no job at all. So yeah, you can have the conversation. Of course, you're then going to get into a dispute about what their employment contract says and why you're amending it. I think it just has to be honest, open conversations. Without knowing the terms of individual employment contracts, I can't say whether you would have the rights to do it under the letter and the words of every contract, but I think you have to have a sensible conversation and say, because of what's happened, because of the lack of people now coming to the gym or the lack of members signing up for next year, whatever it may well be, I think you have to be able to be comfortable enough to have that conversation and say, your 30-hour job is now 15. I don't know if it's going to be this in 3 months or 6 months' time. Let's revisit it, but this is my proposal. And the individual might not accept that and may choose to leave, but I think that's a better option than you having to pay for someone who has nothing to do.
So is that role then technically redundant? And therefore, if it were to pick up again, you could potentially take, I mean, I'm just sort of throwing around ideas here. You could take on someone else then?
So effectively, you can amend their contract to sit for a new role. And if it's someone you like and someone you trust and someone that's worked well for you, you would want to do that.
Yeah.
If they refuse to, then I think, yes, you say the role is redundant, and then you can hire for a new role, which, if you go through the right process, is absolutely fair, because effectively you would say, you had a 30-hour role, it's now 15. Are you wanting it? No. Okay, well, the 30-hour role is redundant. I am now going to be recruiting for that 15-hour part-time role. And there may be different responsibilities attached to that role as well. I mean, it may well be that that person needs to come up with a health and safety checklist for coronavirus. That certainly didn't exist before.
So are you saying, Adam, as long as that role has changed, the former role is redundant, but this Correct. Is a new role with new needs?
Correct. I think you'd want to keep on the person you've got under a new contract for that new role. But if they do not want to do that, then yes, you can say your role has become redundant. I've offered you that new role. You don't want it. Therefore, I'm going to have to go through a process of recruiting someone for that role. Your role no longer exists. And that's the end of it. So yes is the answer to your question. And as I was saying, you weren't all on the call when I said this, but if there's any questions that you would rather aren't recorded, then we will have a space at the time of the hour where we can address furlough and specific employment issues. So if you have anything that you'd rather wait until the end, then feel free to note that down and we can happily come back to it. And as I said, I'm in no rush, so we can stay as long as you need to go through those questions. So if we move on to furlough, to the one other point actually, sorry, one other point I should make, sorry, just as I turn the page, you can rotate furlough. So if you have more than one employee who's on furlough just now, you can start rotating it as well. So you might say to someone, you're in this week, someone's in the next week. So there is the ability to be flexible with the furlough scheme as well. Just remember that as well. And that ultimately applies if you've only got one employee as well. You can say to them, I only need you every other week. But there is the ability to be flexible in terms of when you bring people back and how you allocate time and roles between people as well. So that is furlough. The next topic is rental issues, number of gymnasts in the premises. How do we approach going back to the premises which we hire an hourly rate? How many gymnasts can go back? And does this impact on the hourly rate which we need to pay for the hire of the premises? Does rent have to be paid for lockdown? And how can we terminate the rental agreement as classes cannot be run due to government guidance? So quite a few questions there. I think what I will do, I'll actually leave these on the screen actually, because I think there's quite a few issues there that would be useful just to remember as we go through them. So how do we approach going back to the premises which we hire at an hourly rate? At this moment in time, unfortunately, you can't actually go back the premises. It's as simple as that. Government advice is that indoor sports such as gymnastics cannot take place at this time. Now, I appreciate it seems a bit odd that some of the clubs may take place in schools, where schools are open but you cannot do gymnastics in there. That unfortunately is the government ruling at this time, and the reason for that is because of touch points. So if you are on some form of apparatus and someone's put their hand on it, going through the process of disinfecting that is the reason why the clubs are not open at this time. So government advice is indoor sports cannot open at this time. That will change very soon, I suspect, and touch point the issues. In terms of the how to go back, it will depend on the individual lease that you have with the person that you hire the property from for your classes. What does the lease say about your access to the premises is something to think about as well. Are you in open discussion with the landlord, if we want to call him the landlord, about when you can go back and under what circumstances you can go back? Do they have a risk assessment or a health and safety form that they've provided to you? These are the sorts of issues that I think it's worth thinking about to make sure that you feel fully comfortable that anyone that goes into your premises is not going to be at risk of getting the virus. So once government guidance is gymnastics can resume, I think the important point is to have a discussion with the person that you rent the premises from, whether it be a school, whether it be a gym, and say, what provisions do you have in place to make sure that you are as secure as possible? And in terms of how many gymnasts can go back, and does this impact on the hourly rate which we need to pay, again, that's going to be down to government guidance in terms of how many gymnasts the government says, or how many people the government says can actually meet in an indoor setting. It may well be that the government says 10 people can or 20 people can. We just don't know. So at this moment in time, the answer is 0. Over time, they will say that a certain number of people can meet indoor for sporting events, but we're not at that point yet, unfortunately. So I'm hoping it will happen sooner rather than later, but we aren't at that stage yet. And in terms of the hourly rate, I think that's a conversation to be having with the landlord. And obviously that links into the next question about, does rent have to be paid? What does the rental agreement actually say in terms of what happens when the premises is closed or unavailable? I suspect that when gyms reopen, the hourly rate will have to stay the same as what it was before, whether you've got 5, 10, 15 or 20 gymnasts, because ultimately the argument will be you could have had 5, 10, 15 or 20 people before coronavirus, so why is it different now? But in terms of what to do about the lockdown period, what does the contract say? Is there a break clause? Is there anything about force majeure? Does the right exist for you to say, well, the force majeure clause said that in the event that access to buildings was prohibited because of a virus or an act of God, we wouldn't need to pay rent? Is that in place? So it's worth thinking about. I suspect that a lot of the agreements that you guys have probably don't go into that much detail, but I would have a look and see if there is anything in the force majeure clause which might give you the right to get out of paying for rent. At this point in time, you have until the end of September without any risk. And what I mean by that is that there's no eviction right of anyone until the 30th of September at the earliest. So worth thinking about that in terms of the ability to push rental payments back until the end of September without being at risk that the landlord is going to evict you. And I appreciate you're not maybe there permanently, so eviction's a strong word to use, but landlords are being encouraged to promote good practice, to have discussions with their tenants, whether it be someone that's there on a temporary basis or a permanent basis or for 3 hours a week or every minute of every day. So I would say have open dialogue with the landlords, see what happens, but they cannot remove you at this point. I've got a few more notes to take, but I've also got a few questions coming in. So let me just go through them as well before I go back to my my next one. So I've one comment here that says now that summer camps can be run with gymnastics and dance in schools, and that's just changed as of Friday. If that's indoor, that's not something that I was aware of, and I presume is the person that asked me the question happy for me to direct it directly to them and see what they say? I think.
Hi, Adam. Yes, it was me. I think Mike knows more about this because Mike, you've got the link, haven't you, from the government's website? It's up to 15 in a bubble.
Yes, so it's 15 children in a bubble. It's when the schools or your local authority finishes for the summer, you can use a school setting or educational setting to run summer camps, and gymnastics was specifically mentioned in that document. British Gymnastics has written to the government for clarification on what that actually meant, because there was some confusion whether only educational sites that had already been proven to be COVID secure would be allowed to go ahead and open. So those in dedicated gyms potentially wouldn't be able to open, and also it was only until September. So there was when the schools go back, there was no guarantee that we'd be then able to operate classes again. So we just need to wait for clarification, I believe. But there's two links. There's one for guidance for parents sending their children to these summer camps, and then there's one for protective measures. So I'll just put the links in the chat here for anyone that hasn't seen it. It came out last Tuesday, but was quite under the radar, or last Friday. Some point last week, but it was very quietly released.
I think it also mentioned that it was only for schools and that you couldn't do it in leisure centres or community centres. So they were fairly specific about the locations, and I think that's probably because they're aware schools just desperately need the income at the moment.
Are we saying then that the elements of gymnastics that can take place are ones that don't have touch points? So dance, I think, is one that you mentioned there, Jessica. So is that effectively, because my understanding from what I've looked at and what I've read is that the response that might come back to British Gymnastics, Mike, is that actually, yes, you can come and use the school facilities, but it will be something that doesn't have as many touch points. So that's why dance might be one that is permitted, because you're not going to be on an apparatus to the same extent by doing dance as you would be by doing other aspects of gymnastics.
It's very hard to tell, isn't it? Because I know that school PE has continued throughout this period. So
yes, I I'm asked to go in and coach in schools, and British Gymnastics researched this, and I could go in and deliver trampoline classes under curricular activities, just not as a private club. So yes, if we had school contracts and they still wanted us in, we could go in and teach as long as it fell under curricular studies.
Okay, so I think where we get to in that is it's a movable feast, I think is where we get to. My view is I think we need to get clear guidance then from British Gymnastics once they have the guidance from the government. So what I have said so far, I would say still stands until we have clear guidance from British Gymnastics what can be done. And it may well be that some elements and limited elements of the sport can come back, but only in limited settings, certainly not a free-for-all. So the points about being able to use a certain venue or reclaiming rent back, I would say they all remain in terms of what I said, and force majeure being a key point. One of the other comments that's come through that's something on my list as well is whether you have any insurance for business interruption. So that's something to think about as well, whether any individual clubs have that in place. Unlikely, because none of us foresaw this coming, but it's something to think about as to whether when you signed up to any insurance policy, which I suspect you all have, there's anything in there for business interruption, which means that if there's a period of time where you're unable to run the club and unable to run the classes, you're entitled to claim against your insurance policy. So that's something to think about as well.
We had business interruption. We specifically, in a number of the questions that we asked that were recorded, we asked about whether there would be, if there were government closures at schools, because that's where our club is based, whether we would get cover. We were told yes, and sure enough, they've now said no, it only covers you in your office, not at the schools. So we were missold without a doubt.
Yes, insurance is a minefield on this, and I suspect the insurance companies are going to be trying to be as difficult as they possibly can. But if you have business insurance, then do try and rely on that as much as you can. Jill, to answer your question about did you see that landlords can't terminate contracts until the end of September, they can't use an eviction right until the end of September. So effectively, you can remain in the premises you've got until then, even if you've paid no rent. They cannot seek to evict you until the end of September. But come the 1st of October, as it stands just now, they can turn around and say there's 6 months worth of rent that has not been paid. You need to pay this or we're evicting you. But they cannot do that until the start of October at this moment in time. And that applies for any commercial premises beyond what we were discussing here, obviously, as well. And that's simply to help with cash flow for various organisations. So hopefully that, I mean, I appreciate it's almost stacking up a liability that needs to exist, but if you've had no income coming in for a few months, and hopefully you might be able to get some in September, then at least it might give a bit of leeway or a bit of breathing space. But as it stands just now, there is no eviction right for a landlord for anyone renting premises until the end of September, even if no rent has been paid. And if you're fully up to date on the rent that you have paid, they cannot evict you. So if you've continued to make your rental payments every month, then it's as normal. If you've made some of them, then I think it's a decent starting position to have a conversation with them and say, I've maybe paid March, April, May, I've had no income for those months, and for June and July, can we defer until 2021? But if you're fully up to date, they have no rights of eviction. If you're not fully up to date, but you've made some, I think you've got a good basis for a commercial conversation. If you've not paid anything, then I think have a conversation, but be aware that they can seek to evict you as of the 1st of October if nothing has been paid, but they cannot do it before then. Worth thinking about when gymnasts come back, and I appreciate this might kind of cut across a couple of the other webinars that are going to happen. Are there certain ways that you can stagger the gymnasts coming back? Are there certain ways that you can limit the numbers coming back? How are you going to deal with social distancing? Just various points to think about within the premises itself. It touches on similar issues that apply for those that are coming back from furlough. But I think it's worth thinking about for gymnasts as well within premises, and also to speak to landlords about it as well. They may have specific rules about how many people can enter the building. They may they may say we want to stick with a 2 metre rule as opposed to 1 metre plus. So these are things to think about and talk to your landlord about as well when you do get back in, because individual landlords may have different rules and different things in place. Hopefully that covers most of the points that were on that slide. I'm conscious there was one there. How can we terminate the rental agreement as classes cannot be run due to government guidance? I think the answer there is really to have a look at the rental agreement, see if there's any right to terminate. If there's no right to terminate, then I think having an honest conversation with the landlord and saying, listen, we're not going to be able to run any classes, we want to terminate this agreement, and seeing if they're decent about it. I suspect most landlords will not be decent about it and will try and insist upon you paying rent and continuing to be there, but that's one of the options that you have, is to have a conversation. But it's very difficult to terminate an agreement due to classes without having a conversation with the landlord, or alternatively having a provision in the lease that gives you the rights to get out, but I suspect that won't really exist. So if we move on to general queries, and these are the final 2 questions that came in, and then we can go on to the interesting bit when we're not being recorded. So do contracts have to be enforced whilst a gym is closed down? And is a parent entitled to a refund of fees paid at the start of the virus? So let's take each of these 2 topics in turn. So the first one is contracts being enforced. It's difficult to know without knowing which contracts we're specifically talking about. The general rule is contracts will have to be enforced subject to any specific provisions, such as what we discussed in relation to business interruption or force majeure, anything like that. I think we've covered the employment bit quite strongly. We've covered the rental agreement bit as well. My view is that contracts as a whole will be subject to a lot of flexibility by both parties. If you've got a coach's agreement, for instance, which is similar to the employment but maybe slightly different, it's very difficult to know how that's going to work out without having an honest conversation with the coach and saying, well, you've not been able to be on site for 6 months, so we're going to have to either extend the contract or bring it to an end earlier, or come to some form of resolution that will make sure that both parties are happy that he or she is still going to receive the payment that they were expecting, but they're not going to be feeling that they've been let down by you. So I think contracts on the whole will have to be enforced, but with some manoeuvring about whether it's deferred payments or whether it's providing a different set of deliverables. But unfortunately, I wasn't able to find out more about what contract specifically that question was about, so it's quite a difficult one to answer. But again, I'm happy to pick up on that if anyone's got any questions on that. In relation to parents paying at the start of the virus, what happens then in terms of the rights or otherwise? Well, I assume that no services have been provided to a parent or guardian in the last 3, 4, 5 months, which is problematic for you. I think the 2 things that I considered here are, what do the T's and C's say? So what terms and conditions, what membership rules are in place that the parent or guardian signed up for on behalf of their child? Did they provide that in the event that the child's unable to attend, there's a deferral in payment? Can there be a credit? Can it be carried over to a new year? There's various things to look at and think about there. A gymnast, unfortunately, can get injured. So what happens in that situation? It's almost a rhetorical question, but if someone was to break their leg and be unable to take part in gymnastics for 6, 9, 12 months, would you still expect full payment to be made for that period of time? Or would you say, we'll carry it as a credit to the following year? Or would they get a partial refund? What would happen? Because I think that the example that would be set then would be quite a good one to use now as well. So I'd look at the T's and C's. I'd think about whether there's the ability to offer a credit, to offer rights that can be used for a following year as well. It's worth thinking about. I did see that British Gymnastics, and Mike might know more on this than I do, have issued guidance this morning about a hardship grant that they are offering to some gymnasts as well. So that's something to maybe look into. I think that email was sent to various clubs this morning, Mike. You might know more on that. And they've also indicated as well, just before you answer that, they've also indicated as well that they might be willing to reduce fees for members, I think it's clubs, for the forthcoming year as well. So British Gymnastics are taking measures to help, but Mike, you might be better placed to answer that on the reduced fees and the hardship grant directly.
Yeah, so you've got your British Gymnastics Hardship Fund, which have a look at the criteria for those athletes that may need it. Then you've got BG have reduced membership at bronze and silver level for the next membership cycle, as long as the payment is made in October. Gold will remain the same price as this year. And then London Gymnastics is releasing a hardship fund, or has already released one, I can't quite remember, for London athletes and families. So that if that hasn't gone live, it's going live shortly, and that's sponsored by the Sewn, the leotard company. So that is coming shortly, if it's not already released.
That's good to know. So thanks for that. So hopefully there are some steps and some helps out there. I do think there's one thing worth looking at as well, is the step forward plan on the BG website is quite good as well. I had a look at that yesterday, which kind of helps in terms of more generally how to get back to business, how to get back to normal for various gyms. So if you've not had a look at that, it's a step forward plan on the BG website is really useful and worth looking at, and it kind of talks you through different stages and getting back to whatever normal is. So hopefully that'll be helpful. So I think there's two remaining. I say remaining, that makes it sound as if we're about to end. There's two remaining things to think about. Number one, questions that you'd like to ask now that can be recorded for others to see, and then questions that you would like to be asked without it being recorded as well. So does anyone have a question that they're happy for cameras to record at this point, or shall we move to the closed session?
I'm happy to ask a question about the step forward plan,
Yes.
because I'm hoping somebody from BG is actually listening and can do something about it. But I found there's some very helpful information on there, but it's really difficult to find. And I think if there was some sort of tool search at the top where you could find the specific things that you're looking for, that would be a lot more helpful, because there seem to be I suspect it's all been put together at haste, and I think there needs to be a little bit more clarity.
Mike, are you best placed to pick that up with BG?
I can. I'm part of the London Gymnastics Management Board, but I will pass that feedback on. Someone is just calling now to find out about the preschool membership for the person that asked, so hopefully I have that answer shortly. But no, I'll just pass that feedback on, Jessica.
Is there any other public questions, or shall we ask James to move us to private mode? James, I think this is your moment to switch off the cameras.
Thank you very much for your questions, Anna, your answers.